afternoon. My name is Jordan Walker. I'm with Seaver Walker Paget Law Firm. Thank you for joining me this evening, this afternoon, to talk about the Dresden Talbot Transmission Line and eminent domain. With that being said, I'm just going to go ahead and get started so we can keep this thing moving. If you have questions as the proceeding or as our webinar goes on, please feel free to ask them as they come to you. And then I will address all questions at the end. But if you have questions, ask them so that I can then address them promptly at the end, or I might answer them in the interim. Thank you again. Excuse me. So today we're going to be talking about the Dresden Talbot 500 kV transmission line project. Again, my name is Jordan Walker. I'm an attorney with Seaver Walker Paget Law Firm. Seaver Walker Paget Law Firm is an eminent domain only, landowner only law firm. This is the only area of law that we practice at our firm, and that is helping landowners faced with eminent domain acquisitions. And that includes against utility projects, that includes going up against GDOT, the county, the city, you name it. We represent landowners in those situations. And we do so. With that being said, in this we like to say it's just a matter of course. We are not with Georgia Transmission. We do not work for the utility company. We've never worked for a utility company. We are here, on behalf of ourselves, to potentially help out some landowners that are affected by this project specifically. Again, we are eminent domain only law firm. I've personally handled hundreds of transmission line cases. We've handled thousands of utility cases across the country, including in Georgia. And really, what we're going to be doing today is relaying or imparting the experience that we have accrued by doing this area of law so much, not only in Georgia but in other states. We've seen basically every type of acquisition you could ask for, any type of property that's being affected. We know how these companies work, how these utilities like to approach these acquisitions. And we know how to get the best possible deal for our folks. And as a consequence, we have learned a lot, like I said, and today we're going to relay that experience so that when Georgia's Transmission starts talking about making you an offer, starts talking about acquiring your land, you will be equipped to handle it. So let's talk about the project a little bit. So the Dresden Talbot transmission line it's the reason why it's called that is that, as you can see in this map to the right, it starts at the Dresden substation in Coweta County, and then it goes down to Talbot County. Substation there is down there on the southern end. So that's why it's called that. The 500 kV, that refers to kilovolts. And just to put kind of a frame of reference, transmission lines, they go from the double-digit kVs. Those are usually the distribution lines you see in municipalities, you might see in your neighborhood and residential areas that are just distributing electricity to homes. This is a 500 kV. 500 kV, it's not quite as big, the biggest it gets, but it's up there. 500 kV is a lot of voltage. These are going to be significant structures carrying a lot of voltage. So just to give you a reference, these are not, not transmission lines you might see in a small residential area. These are significant structures spanning a significant path through Western Georgia. So it's a 66 miles of new 500 kV power line, and they have begun surveying. That began in 2025. We would expect, this is from the Georgia Transmission. This is information pulled from them. Again, we go off research we find online, information that we follow. This is based on their estimates. They're looking at surveying to begin this year. And then you're looking at construction to probably not begin for, excuse me, at least 3 years. So what that means is that if you're a landowner affected by this project, you might not have heard from them yet. That's fine. That's to be expected. But if they need your land, if and when they need your land, they are going to contact you and they're going to issue an offer for your property. They're going to make their presence known. So If you haven't heard from them, it's not a big deal. I don't think a lot of folks have heard from them yet. I think this is the first thing. First, our letter is the first thing a lot of people are hearing about this project in general, which is good because that means you're ahead of everything and you're not too late and you're not too far down the line. So let's talk about eminent domain and why is it relevant? Why does it matter and what does it mean? Well, Georgia Transmission, as a utility company in Georgia, has inherent eminent domain authority, which means they have the ability to exercise eminent domain. Eminent domain is the power of entities to acquire private land and put it to public use. The most thought of exercise of eminent domain is usually for road projects. GDOT needs to build a road. They need to get some land to do it. They utilize eminent domain. But utilities, Georgia Transmission included, also have this ability. And it works the same way, but instead of acquiring land for roads, they are acquiring land rights for transmission lines for utility projects. And so the same way with GDOT, the same way that GDOT can acquire land using the court system, using eminent domain authority, Georgia Transmission can do the same. So you're not just dealing with your neighbor down the street, you're dealing with an entity that can actually take your land if it gets to that point. So the negotiations that you go through are not traditional. They are not arm's length. The ability of the utility to take the land changes things. It changes the leverage of the landowner. And it also means you can't just say no forever. Eventually, they will be able to get the land. So it changes the negotiation posture. It changes how this process works, and it's not a traditional transaction. I will say that eminent domain, when it gets to that point, is usually the only issue up for discussion at eminent domain is usually money. Some folks, if you want to stop the project or you want to stop the acquisition, you have the ability to raise your objections in eminent domain. But by and large, at that point, and we have done objections to eminent domain takings. I've done them in the state of Georgia specifically. But those are few and far between. They're very fact specific. You need to have a very specific set of facts to stop an eminent domain acquisition. And we've done it. We've done it successfully. And if you think you have a case, we can certainly talk about it. But I will say that just not wanting it on your land is not a good enough argument to win an eminent domain. You usually have to have some sort of other argument that it's not for the public, or that it's arbitrary and capricious and it's not needed, or the route is overly burdensome. That's not even going to do a lot. It's very difficult to win these arguments on stopping acquisitions. Usually the case at eminent domain is over compensation, in other words, what you're entitled to for the acquisition. So let's talk about the eminent domain process, the condemnation procedure. And condemnation is the same thing as eminent domain. It's the procedure. And eminent domain is the exercise of the power, and condemnation is the procedure. In an eminent domain process, before they even can file a lawsuit, they need to issue you a pre-condemnation offer. I talked earlier about how they're going to make their presence known. If you haven't heard from them, that's fine. They will absolutely talk to you about surveying. They're absolutely going to contact you about issuing you an offer if your land is needed. So to those folks that are maybe concerned, they're not around a lot, they're worried that this is going to happen without their input, and they're going to show up one day and they'll be sued. That's not how it works. They will approach you. They will issue you an offer. And that is also where our firm generally gets involved, when the offers are issued to the landowners. So they will issue you an offer. There'll be some level of negotiation, but ultimately, if those negotiations fail, they will file their lawsuit against you, they being Georgia Transmission, to acquire your property through eminent domain. The lawsuit is filed in the state court in the county where the property is located, and you are entitled to a jury trial over just compensation if you ask for it at litigation. And so that is a good piece of information for landowners. So this is kind of the beginning to end. You receive the offer. If the deal can't be met, they file their lawsuit. If the deal still can't be met, then eventually the case will end up at a jury trial where the arguments are over what you're entitled to, how much money. So that's kind of a nuts and bolts. I will say that just because, just because they have eminent domain doesn't mean your case is going to require eminent domain. And beyond that, just because it's going to require, maybe it requires eminent domain, does that mean you're definitely going to have a trial? You might not. I'll say that generally speaking, these cases do not require litigation. And generally speaking, the ones that do require litigation do not require jury trial. And when I say litigation, I mean eminent domain. So so just because this is the process and you have the right to this process is for landowners just as much as it is for Georgia Transmission. And if you want your right to a day in court, you will enjoy it, you will have it. So that's the process. I want to talk about the offer that they're going to eventually issue to you. If you aren't familiar, and a lot of folks aren't, what they're going to want from you is an easement. And an easement is effectively a deed. It is a deed. It's a deed of property rights from the landowner to the easement holder, generally. But instead of deeding the entirety of your land, you're deeding the right of the holder of the easement to do what the easement allows them to do. Generally, the easement is the right, or ostensibly, this easement will be the right to build and maintain a power line on this acreage on your property. Now, that's ostensibly what it should be. What the easement ultimately ends up saying might not say that. It might allow for a lot more than what you might have bargained for. A lot of times in these cases, and I haven't seen the easement that Georgia Transmission's presenting on this project, but a lot of utility companies will go to landowners with easements that are very broad, that give the transmission line broad rights to do way more than what you thought you were bargaining for. I've seen easements that allow broad access where they can access, across, they can come in from any angle they'd like across the property. I've seen easements that have no clauses for future damages I've seen easements that where utility companies draft away liability for problems that happen on the easement. I've seen utility companies draft easements that allow the right to add more power lines whenever they want and for no other money, no additional money to the landowner. I've seen easement that limit the liability of the power line that add the right to add fiber optic cable within the easement, again, without money for you. The bottom line is that the easement determines what rights Georgia Transmission has on your property. And if the easement says they have the right to build a pipeline, even though they're not ostensibly building one, they can build it. And if the easement says they can build as many power lines as they want, wherever they want on the property, they'll be able to do it. And what's more, that easement that you signed that gave them the right to do all that in 2025 will be on the property forever. So when you sell the property, when your kids inherit the property, when your kids' kids inherit the property, this easement will be there. And that easement language that maybe you didn't give a second look to, it allows for all sorts of things that now your kids or your grandkids have to deal with. Ancient easements become modern easements because the holders of those easements know how valuable they are. And they can sneak rights in there that make those easements more valuable, whether it be the right to add fiber optic cable, the right to add a pipeline. They will try to do it because that easement becomes that much more valuable to the utility company. So just remember that that there's more than generally what is told to landowners in these easements. I would definitely have an attorney review any easement that they want you to sign. I've seen too many situations where landowners sign documents they should not be signing, and those problems reveal themselves down the road. So we talked about easements. Let's talk about money. And those are really the two components of everyone's acquisition is what does the easement say? What are you able to negotiate out of that easement? And how much compensation are you able to get? Are you being fairly compensated for your property? And I've included what I believe I deem to be a complete compensation package. That is a package where it's comprehensive and includes most, if not all, of the components of damage that property landowners will incur. You should have a proper price per acre. You should have proper payment for crop damages, up to 5 years if more. Timber damages as well, if there's timber. Payment for anticipated ground damages or a clause requiring remediation. A lot of times when they construct these lines, they do a lot of damage, both to terrain, the water path on the ground. I mean, there's an unending number of issues that can cause erosion that can pop up during these construction times. They're going to be using, of course, heavy duty equipment. They're going to have trucks. There's going to be compaction. So it's imperative that you consider what damage this equipment might do to the land and whether or not you are protected if they do mess it up and they don't properly restore it. It should include a proper consideration of all damages. Field tile, irrigation, compaction is going to be a big one for agricultural property. You know, we talked about timber damages. If there's fencing, if there's livestock, all sorts of issues. You know, landowners, they have an endless number of issues, of course, that are going to arise from this type of acquisition. And so it's imperative that you are getting properly paid for those damages, either beforehand or you have an easement that demands their payment when the damages occur. And this is all in addition to what's been offered by the utility, and then also residual damage. Residual damage refers to any impact to the parcel outside of the easement, the parcel's value outside of the easement. In other words, let's say you have a 40-acre tract, and they want to run their line right through the middle of it. And they do. But there's another 40-acre tract that's right next door that is, for all intents and purposes, identical to yours. But it does not have a power line on it. So you have two 40-acre tracts right next to each other, identical. One's got a 500 kV power line on it, one doesn't. The difference in value between those two parcels is residual damage. How much less is somebody going to pay for that parcel than they would have otherwise, but for the power line? How does the power line contribute negatively to the overall property's value? That is residual damage. It's called diminution in value. It's called consequential damages. It's called severance damages. They all mean the same thing. And it's how does this power line impact the value of the entirety of the property? And you're absolutely entitled to compensation for it. It's also something that utility companies rarely offer, if acknowledged at all. Okay, and so we talked about money, we talked about the easement. Let's talk about who's going to be presenting these documents to you, and that will be the right-of-way agents. Right-of-way agents are land agents that are hired by companies, third-party land companies that are hired by companies like Georgia Transmission to go out and get your land. Simple as that. Their duty, their job is to come to you and sell you on the idea of you selling them your land. And they have strategies. As any saleswoman would have, they have strategies, they have tactics that they employ, that they deploy when they're dealing with landowners. And they've been, they're good at what they do generally. So these are tried and true methods. And my job right now is to tell you to get power through that and remember who is paying this right-of-way agent, and to just have some skepticism for what's being told to you by these folks. I don't think a little bit of skepticism is healthy in these scenarios. And so I remind folks who is paying the right-of-way agent. You're not paying them. They are being paid by the utility company to lock down your parcel, to get your parcel in their hands. That's their job. That's what they're getting paid to do. So remember that when they come to you and they talk to you and they talk about, wanting to be a good partner and wanting to be a good steward and being, they do the same thing in each project. Just maintain that skepticism and definitely approach it with caution. So, and we've seen these are some tactics we've seen. These are all geared towards the same goal, and that's getting you to sell them your land, not only to do it, but to do it quickly. The quicker you sell it, the better it is for them, by and large, because they get the land quickly. They don't need to worry about it. And a quick decision is usually not a great one in these scenarios. A quick one, you can certainly always sell it, but there might be issues with the language. The money might be low. They love a quick decision, and it's on you to not make one, of course. But we've seen these, again, these tactics employed by right-of-way agents to get these quick decisions. They offer bonus payments to incentivize signing. They talk about lowering, raising numbers. Uh, they like to talk about ignoring the big dollar issues like residual damage and property damage, and they love to focus on having conversations on the low dollar items like price per acre. That is a low dollar item. They're haggling over $2,000 an acre on a 3 acre acquisition is not a ton of money, and they would love to have a conversation over $6,000 as opposed to having a conversation over $60,000 in residual damage or property damages. So they love to have conversations on the low dollar items. That is their goal, one of their goals. Ultimately, if you aren't sure if you have a good offer, it's as simple as giving me a call, shooting me an email, shooting me a text, and sending it to me, and I'm happy to look at it for free, and then give you my thoughts on the offer and what I think you should do. And I also do that for free. So if you have an offer, you can send it to me for free. I will not charge you for it. I will give you my thoughts. You can decide what to do. So let's talk about what to do, what not to do when you receive an offer, when you're about to receive an offer. What to do when you're going to receive an offer, you're about to receive it. Insist that the right-of-way agent can communicate via email only. They love to have in-person discussions. They love to talk over the phone, all these, in-person chats. They do it because there's no record. There's no record of what they promised, what they told you, what they didn't tell you. They can make all sorts of promises verbally that don't make their way onto the final documents that you sign. So I tell folks to keep all the communications via email or text, as long as there's a written conversation that, a record, so to speak. Once you receive the offer, inform the right-of-way agent that via email to say, thank you, I will review this and get back to you in a week. And then you take that offer, you send it to me, or you send it to your attorney, you have the attorney look at it, and then you go from there, and then you respond. Again, avoid in-person discussions, avoid in-person negotiations. A verbal promise means nothing when you're talking about conveying property. What not to do. Do not engage, don't jump into negotiations or start talking about value before talking to your attorney. It might seem instinctive, and a lot of folks are probably just going to jump in and start negotiating despite my advice otherwise. But the reality is that you don't know what you're entitled to, at least not yet. And you might think you're doing yourself a service by negotiating off of their offer, but there's a decent chance that you're not doing yourself a service at all. In fact, might be hurting your case. And an example would be, let's say they come and they offer you $20,000 and you say, well, I'm going to get 40. And then you say, I want 40. And they say, okay, we'll do 40. And then you call me up and you're having second thoughts, and I look at it and I say, whoa, you should be getting 60, 70, 80, maybe 90. And I asked you, did you talk with them? And you say, yes. And I say, what did you say? And you said, I'd take 20. And I say, well, now it's going to be very difficult because you told them what you would be willing to take before you knew what you were entitled to, what you could potentially get. And they know that. And they wrote that down. They wrote down that you take 20, and that's going to stick with your negotiation record the rest of the case. It's going to be with your record. It's going to be with the right-of-way agent. It's going to be with Georgia Transmission's attorney. They will know. And it's going to be incredibly difficult to get anything more than that once you've said you would accept it. So that you showed your hand before you even knew what the hand was. So again, don't jump. There's plenty of time to negotiate if you want to do that on your own. But I would, before you do that, talk to somebody before you jump into that. Don't go go out and get an appraisal or an appraiser. It'll be very expensive and it might not be necessary. In fact, it very likely will not be necessary. A lot of folks want to go out and get some evidence. You don't necessarily need evidence. You might save some time, save some money, and get to where you need to be without spending all that money. And they are not cheap to get power line appraisals. I'll say that. Don't meet in person. We talked about that. Don't take promises at face value. We talked about that. And then we also talked about the interests of utility and don't assume that they have your interests at heart. And then finally, don't make a rush decision. We talked about that, but also don't let this be something that kind of sits and lingers and you don't address, put it on the back burner. You're not doing that because you're at this webinar right now. You're already ahead of the game. But when they come through and they make an offer, I tell folks, don't let this be a situation you forget about, and all of a sudden you're in court. You don't even know what's going on. It has unfortunately happened too many times. Okay, and this is my second to final slide. This is how this is about our relationship, how our relationship with our clients, and then the next slide is some parting thoughts. So if you have questions, again, please type them now. Go ahead and use the Q&A or the chat, and I'm happy to get to them at the end of the presentation. This is our standard agreement with our clients. This is how we work. This is how we have our clients. This is the relationship we have with our landowner clients, and that is a contingency fee agreement. And a contingency fee agreement, in this agreement, our fee is contingent on how much more we get than what is offered by Georgia Transmission. So let's say they come through and they make you a $10,000 offer, and you hire our firm, and we get you $50,000. We added 40 to the case. We collect 1/3 of the 40, and you end up with almost 37,000, almost 4 times the original offer. The reason why we do this way is because, and this is an example, I should say, this is not a guarantee. The reason why we do this is that it puts everybody in the same boat. We're partners in this scenario. We're all incentivized towards doing the same thing. You can trust that the work I'm doing is on your behalf because, again, I'm in the boat as well. And the outcome, I'm affected by it as well. So we are incentivized to do well for you because doing well for you means doing well for ourselves. It also allows landowners to hire us without coming out of pocket. We understand nobody wants to hire an attorney in this scenario. It's not something you asked for. This allows landowners to hire us without having to shell out some bucks just to retain our services. But if you are interested in a more traditional legal relationship, attorney-client relationship, we do have retainers. We do an hourly rate, and we bill as well. So generally, landowners don't prefer that because they don't want to spend all that money. But if that's something you're interested in, we can absolutely talk about that on a one-on-one basis. Okay, and this is my last slide, and with this, I will take questions if there are any. I will say next step moving forward, as soon as you receive an offer, you should hire an attorney. Until that point, I would just start, vetting your attorney options, talking to folks, considering maybe what you plan on doing, getting a plan going. If there's survey stakes out on your property, or if there's surveyors come by, you'll be able to see at least on the ground where it's going because the survey flags will show the path of the power line. So that'll give you some information as well. But other than that, there's not a ton to do until they come to you and start talking to you about making an offer. That's when you need to start jumping into action. If you have a group of landowners, that is the power of a group is immeasurable. The more folks that are represented by the same council, the better it is for each individual landowner. It's not necessary, but it's something that, if possible, I advise landowners to do. And then finally, if you have an offer, or eventually if you get one, again, I'm happy to give you a free review. You can email it to that email address. You can text it to my cell phone. You can fax it as well to that number right there. Whatever's easiest for you. You can mail it if you'd like. Whatever's easiest for you. Okay, so that is the end of my presentation, and I will open it up for questions if there are any. Okay, I'm not seeing any questions, which is not a problem, not an issue. If you have questions that you maybe want to ask individually, you can email me, you can text me. I'm not going to bill you. You're not going to get an invoice for my advice. Just don't hesitate to start a dialogue. I'm happy to answer any questions you might have. Yeah, so thank you for your time. I appreciate it. Everybody, have a good night and reach out when they start bugging you. Thanks.